I'm James Turk. I'm a director of the Gold Money Foundation. I'm here with a longtime friend, Reg Howe. Reg played a key role in the early days of GATA by taking on, as Chris Powell describes it, all of the money and power in the world with a case that was brought in federal court in Boston. You know, the results of the case and everything surrounding the case are well known, but you know, ever since then, which I guess was what, 2001 is when the case was brought forward, or a little bit later than that, perhaps?
Yeah, I think it ran 2001, 2002. I'd have to go back and look at the dates, but roughly that time frame.
There are some interesting elements to it, and it also leads to the bigger picture of, you know, constitutional money. You know, what is constitutional money in the United States? And I'd sort of like to explore that topic with you, because you did give a brilliant presentation at the GATA conference here in London on this particular topic. And you know, what's quite clear to me is that what we have today is not really constitutional money.
No, it's pretty clear under the Constitution that money should be linked to gold or silver. That's the way it was before the Civil War, and nobody prior to the Civil War would have ever suggested that the legal tender or the constitutional standard value could be anything other than gold or silver. And then we went through several stages. During the Civil War, because of the financial problems, the government issued greenbacks, which were a paper legal tender. You might expect the constitutionality of the greenbacks was challenged. Cases went against them first, and then a rehearing or new case was brought, and finally the Supreme Court in the legal tender cases said that the greenbacks were constitutional, but they went out of their way to say that the government could not make paper money a standard of value, and they treated the greenbacks as if they were a promise to pay gold dollars, but at some later time. A few years later, and there was also always at that time the question of whether maybe it was, if it was okay, maybe it was just okay as a war measure. A few years later, sometime around 1876-7, about the same time that the United States was going back on the gold standard after the Civil War, the Resumption Act had been passed. Another case came before the Supreme Court on the greenbacks, and the court basically said the government had the power to make paper a legal tender, war or no war. But as I say, it was kind of academic. There was a lot of controversy about that case. Most people regarded it as a wrong decision in terms of constitutional law, but because the country was going back on the gold standard anyway, it, as I say, became kind of academic. It didn't really resurface until the New Deal and the confiscation of gold and the devaluation of the dollar, and then it provided some precedent for the so-called gold clause cases, where the government wanted to avoid paying its bondholders. Well, what had happened is, as a result of the greenback, most bonds had a clause in them that they were repayable in dollars at the existing parity, so that if there were a devaluation, you were still going to get the equivalent amount of gold.
This is the so-called gold clause.
Right. So these were the gold clauses that were basically, by that time, in pretty much all major financial transactions, bonds, stuff like that.
Reflecting the fact that gold is really the standard of value, not some piece of paper called a dollar or a pound or something else.
Right. Right. That the dollar or whatever that piece of paper was accepted at a certain parity, a certain exchange rate with gold. And when you got repaid, you were supposed to, in effect, get the same amount of gold back. So the case that finally got to the Supreme Court, technically the Supreme Court never really ruled on the confiscation issue. That had been ruled on in lower courts, but it wasn't really challenged in the Supreme Court. In the Supreme Court, as you might expect, the bondholders were trying to get paid at the old parity. That is, they
$20.67 per ounce.
They wanted that amount of gold, or the equivalent, so they wanted, you know, for instead of at the $35 an ounce. And the Supreme Court somewhat divided opinion, but ultimately by one vote decided that the government was able really to evade paying at the old parity because, as they put it, the dollar still had the same silver value and it still had the same buying power as before. So despite having a lot of nice sounding words about the government's obligation to make good on its debts, they basically did get away with paying at the new parity. But the key thing about all those cases is that the dollar was still always defined with reference to gold or silver.
Right.
Even though we couldn't own gold, the dollar was still $35 an ounce.
It was the standard of value for measurement.
So it was the standard of value. And that really didn't change until Nixon closed the gold window in 1971.
Yeah, and we now have fiat currency.
Completely fiat system since.
Backed by nothing except government promises, essentially.
And that basically frees the government from any discipline over the issuance of money or creation of debt or sale of bonds, et cetera, et cetera. So
the gold clause cases in the 1930s, were they by implication also saying that the government had the right to break a private contract? Given the fact that, you know, it was quite clearly stated that it was at the option of the holder of that bond that they had the right to take delivery in gold.
Well, there were actually 2 or 3 gold clause cases that were consolidated before the Supreme Court. And only one of them involved government bonds. The other involved, as I recall it, railroad bonds, but they were private bonds. And so when it came to the issue of private bonds, the court, and I really have to go back and take a closer look at the opinion, but the court basically got into an issue of, well, whether those clauses could interfere with the government's monetary powers to set the gold price. Nobody doubted that this Congress had the power to set the gold weight of the dollar. And so there was a question in those cases whether, if Congress decided to change the gold weight of the dollar, somebody in a private contract could interfere, so to speak, with that power. That was one set of issues, but in the government bond cases, then you had the issue that you're raising, which is the government's promise to pay you X weight of gold once you make the translation from the parity through the dollars. Can they change that contract? And the court struggled with that because the court didn't really think, you know, the government just doesn't have the power to change the terms of the contract under which it's borrowed money. But the way they kind of got around it at the time was to say, but actually the new dollars are worth, in terms of purchasing power, the same as the old dollars. So we're going to let you get away with it.
Yeah,
this
so
time.
it's skirting around the edges.
The truth is, the way it's phrased, I mean, if that hadn't been true, the court probably would have come out the other way around.
Yeah. Have there been any major court decisions since the 1930s?
No, that's it. It's another very interesting thing about all these cases is that the legal tender cases, and there was an earlier series that found the Greenbacks unconstitutional. Then there was a change in the composition of the court. As I recall it, actually 2 judges retired and 1 new one was appointed, or they left. And so they had a different lineup. And so they went from 1 vote against the constitutionality of the Greenbacks to 1 vote in favor of them. But they were, 1, controversial, and 2, they're very lengthy opinions. I mean, I can't remember the number of pages, but you know, it takes up a chunk in the law books that's pretty good sized. And the same is true with the gold clause cases. I mean, these were huge cases when they were decided, a lot of public interest, and since the gold clause cases, well, really there wasn't any reason to get back into this subject until Nixon closed the gold window. And that's why you would have thought, you know, for the Civil War, you had the legal tender cases. Then for the New Deal, you had the gold clause cases. Nixon was going to close the window. As I said, there should have been the fiat money cases.
Yeah.
Because it's a different issue. Whatever you, you can make perfectly good arguments that the legal tender cases and the gold clause cases were wrongly decided. They probably were. But the link still existed. And so what Nixon did was just an order of magnitude different. And as I say, there's really no way that the fiat dollar can be squared with the language of the Constitution. Therefore, the courts have been very reluctant to take this question on because they can't write a decent opinion in favor of the fiat money, but they don't really want to interfere with the system. I mean, it's just one of these issues that scares them too much.
But isn't the court supposed to be, outside of the political influence? And I mean, even the case where you're saying it was 5-4, they switched the membership of the court over a period of years because of retirement and whatnot, and it went 5-4 the other way. I mean, facts are facts. Law is law. English is a very clear language in terms of what's written. So it sounds like there's a lot of subjective judgment that went into those decisions.
Well, obviously, I mean, the problem once Nixon took us off any semblance of a gold standard, because of course, as you know, it wasn't really a gold standard.
Yeah, exactly.
I mean, at that time, you have to remember that. I mean, I can remember I was in graduate school in the 60s, and it was pretty clear the Bretton Woods system was breaking down. And the big debate was, well, what do we do? And there were basically two schools of thought. One was we just go to floating rates. That's a great system. Let the free market decide. And of course, everybody assumed that that would be done on the basis of trade balances. The idea that the capital markets would be dictating the exchange rates didn't really occur to anybody, let alone the idea there'd be all these traders with computers, et cetera, et cetera. It was just, if floating rates, trade balances, it'll work out with the right exchange rate.
Like it did under the classical gold standard. You're talking about trade balances, not capital markets.
Right, exactly. And then the other argument, basic argument, was we'll raise the gold price.
Which is what Roosevelt did after the the boom and bust of the 20s and the early 30s. He just devalued the dollar.
I think that maybe $50, maybe $70. If they'd done something like that, then you would have had a link that would have lasted for some period of time. I mean, these things can never really be set in stone. I think going back to World War I, which basically resulted in so much debt being issued that the old parity of 2067 was really no longer sustainable. So Roosevelt, the devaluation was probably the right thing to do. The interesting thing is that his most severe monetary critic was James Warburg, who was the son of Paul Warburg, who was basically usually regarded as the father of the Federal Reserve, and was a hard money guy. And Warburg started out as, James Warburg that is, as Roosevelt's monetary advisor. He went to the London conference and so on and so forth. But his view was the devaluation was the right thing to do, and that's what was needed. But then once you went to $35 an ounce, you got to get back on the gold standard as quickly as you could. Put that in place and then move forward from there. And that was not really what Roosevelt did. He played around with the price for a while, and Warburg didn't think that was appropriate, and he wrote this fairly scathing book, The Money Muddle, criticizing the Roosevelt policies. And of course, there was a break with Roosevelt, but then the war came along, and everybody got back together to fight the war.
Well, there were other priorities at that time.
And the $35 lasted through the war and into the Bretton Woods system. And as I say, but I can remember very well in these debates in the 60s, the argument floating rates versus raising the gold price. And at least the two graduate schools I happened to be at during the time, usually it was 10 for floating rates and 1, frequently me, only 1, in favor of raising the gold price.
Yeah, I remember those debates as well, because I was going through my economics program in college at the time, and it was a similar type of situation. You know, so many people were in favor.
Well, the economists were
supposedly floating rates were the modern thing to do. Supposedly.
Yes, and economists were all in favor of floating rates, but remember, it was basically the only way we were going to finance the welfare state.
Yeah.
And at that time, it's kind of a free ride. I mean, you can go along issuing paper money if you do it at just a moderate rate for quite a while before you get into the kind of problem we're in today.
Yeah.
You know, that we could have postponed this problem if we'd been a little more cautious and issuing more debt, more money.
And
but
less
at some
promises.
point, I mean, this is just the history of paper money. Somebody today at the conference mentioned Andrew Dickson White's Fiat money inflation in France. And what he didn't say is why the book was written, because it was written as an essay to support the return to the gold standard after the Civil War. And he actually read it to, not in Congress, but to a fairly wide assortment of Congress persons and senators in support of the Resumption Act, which was the act to go back on the gold standard. I mean, but that's why he did it, and he used the assignats and revolutionary France as the example of what happens if you go to paper money. And I can remember there's some line in that book about Napoleon when he came to power after the French Revolution, saying, I will pay specie or I'll pay nothing. Yes. And putting France back on a gold standard, and despite Napoleon's defeat subsequently, France really on gold standard didn't suffer terribly badly.
Yeah, we just did a video for the Gold Money Foundation on this very point, fiat money inflation in France, and we actually used that quote from Napoleon, and they were on a gold standard from the time that he was assumed, you know, the position of emperor in 1800 until 1914. It had a very stable currency. But there's one other thing I want to cover from your presentation this morning that I found very intriguing. There's a quote that you used from Webster about legal tender. Can you talk about that a little bit?
Well, the reason I used that quote is because it pretty well summarizes what the Constitution says about the subject of money.
The essence of that is?
Yeah. Well, and it's basically that as far as the states go, they can not issue paper money, and the only thing they can do is make gold or silver a legal tender. And with regard to the federal government, since the only power it's given is the power to coin money, it doesn't have any power to issue paper legal tender.
Can't print money. Can't
print money, because the power is to coin money, or to also to regulate the value of foreign coins, which actually is what the first Congress did. They basically took a sampling of all Mexican silver dollars that were in circulation at the time and determined kind of the average weight, because in those days, I mean, coins circulated for a long time and they got worn down a little bit, and so, you know, you just figured out the average weight of the Mexican silver dollar, the pieces of 8 that were in circulation, and that became the weight of the US dollar, which was, once the world went on the gold standard early in the 19th century, they basically did a translation to the gold weight, and for most purposes that became the dollar. And that's why the silver weight lasted until we gave up the silver dollar in the 60s, kind of thing.
Right.
The weight in silver never changed.
371 and a quarter grains of fine silver.
The weight in gold changed, but the weight in silver never changed.
Was Webster arguing for a legal tender, or was he saying legal tender is not necessary?
The interesting thing is the debate was on what was called the specie circular, and it came about the time of Andrew Jackson's battle with the Second Bank of the United States. And I believe, I'd have to go back and look to be absolutely sure about this, but in that period, Webster was almost certainly also the lawyer for the bank. I mean, he had a number of conflicts of interest in terms of, which is why he got into so much trouble after the 7th of March speech. But in those days, the monetary argument, the way you won it, was to paint your opponent as being in favor of paper money. In other words, both sides of the debate were clearly for gold, silver as legal tender. And that's why the beginning of that quote, it was just so long I couldn't do the whole thing in a speech. Webster defines currency. And he basically says, you know, currency can be almost anything that settles debts between people and businesses. You know, whatever adjusts and settles balances.
Whatever people agree to.
In commercial context.
Yeah.
Then he goes on, but if by money you mean the legal tender, the constitutional standard value, then it can be nothing but gold or silver.
Right. It's not paper or anything of that nature.
It's not paper, and I used it because, I mean, Webster was basically, let me put it this way, I think the number is right, he argued 170 cases in the Supreme Court. Nobody's ever come close since, including some of the most famous cases. But his most famous argument, I suppose, was the reply to Hayne, where Webster was arguing that the United States was basically a compact of the people, and that you know, it really wasn't just a compact among states. So that states, he was arguing against Calhoun's theory that it was an agreement among states and individual states could secede. Mm-hmm. And so it became kind of the argument that Lincoln adopted in saving the Union. Because if you read the Constitution, you might just, you know, even a careful reading of it, say, well, this could be interpreted as a compact among states. Mm-hmm. It got ratified state by state. And so Webster, in his reply to Hayne, had gone into some detail about the history of the Revolution and so on and so forth, and maintained that, you know, it was a union. And then Webster, in 1850, came out in support of the Compromise of 1850, which was kind of a compromise in terms of new states, slave states versus. But it was also an issue of enforcing the Fugitive Slave Clause, which required that slaves be returned, you know, if they basically escaped from the South and were in the North somewhere, which of course in Massachusetts there were plenty of abolitionists, and were harboring fugitive slaves.
Yeah, this is when Thoreau wrote his famous civil disobedience, and ended up going to jail for refusal to pay the tax that ultimately was to be used for, as I understood, recall from reading it, helping to assist in returning slaves back to the South that were captured in Massachusetts.
Yeah, and part of the compromise was that we're going to have to, you know, enforce the Fugitive Slave Clause, which was at that time part of the Constitution. Yeah. And Webster's argument on the 7th of March, which was sort of his last big performance in the Senate, was essentially that, you know, we've got to make this compromise, and that the Fugitive Slave Clause was part of the Constitution, and you didn't get to pick which part you were going to abide by and which part you weren't, that you had to enforce the whole thing. And for that, he was basically pilloried at home by what was probably the greatest collection of literary lights that ever took on any individual politician. And he essentially lost any chance he might have had to be president, which of course is...
He was that popular at that time.
Well, I don't know, you know, some people read Stephen Vincent Benet's The Devil and Daniel Webster. Yeah. And he's described as, no, he was never president, but for most of the 1830s and 40s, up to his death, I think in 1852, he was the biggest man in the country, is the way it was put. And I think for the next half century after his death, he was by far the most quoted politician in Congress, in congressional debates. But he's sort of been eclipsed a little bit in the 20th century. But again, it's because he was a conservative, a Federalist.
Federalist, as the framers of the Constitution intended it.
Yes, and so, you know, he wouldn't have fit in very well with the notion of the welfare state, I guess is one way to put it.
Well, the quote was an excellent quote. The presentation you gave was brilliant. And the good news is that it's available on goldensextant.com, which is your website. So what's the title of the speech so that when they go to the website, they'll know where to look?
At the website, the title is Constitutional Money, Don't Ask, Don't Tell. And the version that will be at the website has a number of footnotes and even some supplementary material you can get to in PDF from the website, because, you know, the speech had a 20-minute limit, whatever.
Yeah.
And the idea was to provide quite a bit more support for some of the things I said. And also, I think that there's some history in there. There's a bit about Webster that I wrote. There's a copy of the petition that I had to the Supreme Court to try to deal with monetary issues in the first case that I mentioned. So there's a lot of stuff there. There's even the correspondence that I had with the Harvard Law School professors. So people can, you know, sort of see the bigger picture from that.
Well, that's great, Reg. I'm going to be going into the website as well and look at some of those links, because this is a favorite subject of mine, the whole constitutional money issue. Reg Howe, goldensextant.com. Thank you very much. I really appreciated the opportunity to speak with you about the presentation you gave at the GATA conference here. Thank you.